Greetings. Welcome back to the show. Remember the initiatives to provoke, to ignite, and to inspire towards the building of the Africa I want. Today we'll be reading about the Constitution, the rights of the Constitution, the application of the Bill of Rights. So as we start on the supremacy of the Constitution, section 2. And it says, the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it, it is invalid, and obligations imposed by it must be fulfilled. B. Bill of Rights, section 25. Right to property. Point 1. No one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property. 2. Property may be expropriated only in terms of law of general application. Point A. For a public purpose or in the public interest, and B. Subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to those affected or decided or approved by a court. C. Rights of the Constitution, section 7. Section 7.1. This Bill of Rights is a cornerstone of democracy in South Africa. It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. Section 7.2. The state must respect, protect, promote, and fulfill the rights in the Bill of Rights. D. Application of the Bill of Rights, section 8 of the Constitution. Section 8.1. The Bill of Rights appeals to all law and binds the legislature, the executive, the judiciary, and all organs of state. Section 8.2. A provision of the Bill of Rights binds a natural or a juristic person if and to the extent that it is applicable, taking into account the nature of the right and nature of any duty imposed by the right. As a member of BOAF Juro, I'm extremely dissatisfied with the conduct of the following parties in relation to the conspiracy that seems self-evident from the facts and circumstances fully set out below. Point A. On 7 March 2003, I wrote a letter to Mr. Theodore W. van den Heuvel, attached here to marked EN1, setting out the facts supporting my allegation that this conduct in relation to the affairs of the insolvent estates of Peter Trading Limited in liquidation was inconsistent with the conduct contemplated in terms of section 2 of the Constitution. Mr. van den Heuvel, despite the obligations imposed in terms of the section 7.2 of the Constitution of South Africa that binds a natural person like him and a juristic person like D&T Trust to ensure that in terms of section 25 of the Constitution, no one may be deprived of property except in terms of law of general application, and no law may permit arbitrary deprivation of property, refused, failed, and neglected to acknowledge and respond to the serious allegations made therein that Mr. Mutuma Mawere, a citizen of South Africa since 2002, and an Africa Resource Limited, a company that he is the sole beneficial shareholder, were arbitrarily and capriciously deprived of the property that Mr. Mawere personally negotiated and caused Peter to act as Africa Resources Limited's agent in relation to the fulfillment of the suspensive conditions pertaining to the recapitalization of the Schweppes Zimbabwe Limited bottling plant. B. It is common cause that the applicant creditor in the liquidation of Peter was Telnet Zimbabwe Limited, a company whose control and management was divested and deprived based on rights acquired by the government of Zimbabwe based on a decree that directly offends Section 2 of South African Constitution. C. Following the liquidation of Peter, Mr. Van den Hever was nominated by Mr. Gwaradzimba and accepted to prosecute the right, capacity, interest, and title in relation to the assets of Peter, a South African juristic entity. D. By accepting to act as a joint provisional liquidator of Peter in liquidation, Mr. Van den Hever knew and ought to have known that his conduct was immiscible to the rule of law as the alter ego of SMM under reconstruction was then Minister of Justice of Zimbabwe, Honorable Chinamasa, who issued an extrajudicial order that was used by Gwaradzimba to institute legal proceedings in the name of SMM as an organ of the government of Zimbabwe. E. The assertion, recognition and enforcement of rights acquired by force of a foreign decree in South Africa means that Mr. Van den Hever, CCA, and the Master of the High Court, including the judges who presided over the liquidation disputes, were complicit in assisting the government of Zimbabwe to expropriate my fellow members, including Mutumwa Mawere and Africa Resources Limited, of their right, title and interest in the equipment purchased and delivered to Schweppes Zimbabwe Limited without the agents of SMM under reconstruction, the company hijacked by Chinamasa using public power. F. Based on the facts set out in my letter, whose link can be found here. You can find the link on the screenshot down there. It says, point 1. Set out in the letter above, reference letter to Ms. Van den Hever, it was pointed out on paragraph 8, A, section 2, that the late Mr. Kaplan wrote to CCA's employee, Mr. Hennes Swart, as follows. This letter serves to advise that I'm a joint liquidator of Peter. I attach here with copies of 3 contracts in respect of certain equipment purchased by the above mentioned company, Peter, in 2003. The parties to the contracts were disclosed to CCA and Mr. Van den Hever. This was disclosed after CCA had already intentionally and knowingly participated in extortion and fraudulent scheme perpetrated by Chinamasa, who was in terms of the repugnant reconstruction of state indebtedness companies, involving paying a bribe of $2.7 million as a quid pro quo for the release of Peter's equipment that was unlawfully hijacked by Chinamasa and his appointee, Gwaradzimba, to the benefit of Schweppes, CCA, and to the direct prejudice of Peter. According to the record of a meeting that ensued following the late Kaplan's efforts to take stock of the PETA equipment and deal with the property as prescribed by the Constitution of South Africa. The Companies Act and Insolvency Act. Mr. Kaplan did not attend the meeting of 31 July 2006, resulting in Mr. Van den Haver's appointee, Ms. Adendorf, attending the meeting with CCA and Swap Zimbabwe's limited in-house legal counsel, Mr. Daniel Mokoena. Then F.2. The only record of the meeting that we have been able to access is a fax dated 12 October 2006 that was authored and sent by Ms. Adendorf via fax. Point 3. Serious allegations are contained in this fax that stand to be investigated further if this request for an inquiry is granted. Some of the questions that arise from this record that fall to be investigated include: Point A. CCA paid $2.7 million to Chinamasa in order to get the PETA purchased equipment as reflected in the contracts that were provided to CCA by the late Kaplan on 3 March 2006. It is clear that the reference to PETA in the fax by Ms. Adendorf as the supplier of the equipment pursuant to the purchase contracts that Mr. Mokoena disputed as evidence supporting PETA's right, title and interest in the equipment. It must follow that CCA must be fixed with the knowledge of the whereabouts of the PETA equipment. B. To the extent that Mr. Dan Havre has had knowledge of the dispute regarding the ownership of the equipment supplied by ADS, Kraus, Mafia and AF Industries, all European-based original pet farm equipment manufacturers. The failure and refusal by both CCA and Mr. Van den Havre to follow the trail of the documents, funds and physical equipment from the manufacturers to Zimbabwe where the important equipment was situated at Swap Zimbabwe Limited suggests a conspiracy and conduct that is inconsistent with the Constitution. C. It cannot be disputed that property does not self-create to allow both Mr. Van den Havre and CCA with the knowledge and complicity of the Master of the High Court should be indifferent when confronted with evidence provided by CCA's legal counsel, Mr. Mokoena. That point 1. Flame or SMM paid PETA the funds to acquire Swap Zimbabwe Limited equipment, and at the time of SMM being placed under reconstruction and consequential liquidation of PETA and appointment of the joint liquidators including Van den Havre, the PETA equipment was specially installed, suggesting that the delivery of the equipment preceded Kwarazimba's appointment as administrator. 2. Common sense, logic and reason would precede any right, title and interest being vested in Chinamasa. 3. It was represented by Mr. Mokoena that Kwarazimba's reason for impounding the PETA equipment is that Flame or SMM had a financial interest in the equipment that entitled him to hold on the equipment based on an untested allegation that a reconstruction order existed. As a matter of fact, in relation to the affairs of Swap Zimbabwe Limited and the equipment that the later Kaplan had asked CCA to disclose its whereabouts to no avail, and to Swap Zimbabwe Limited was purportedly removed from reconstruction. 4. It was made a condition for Chinamasa to issue a decree of 26 January 2006 to remove Swap Zimbabwe Limited from reconstruction. 5. No facts exist supporting the allegation that Swap Zimbabwe Limited was ever placed under reconstruction, let alone that the PETA equipment could be subjected to a law of Zimbabwe, and as such legal and valid authority existed allowing both Coca-Cola Africa and Chinamasa to divest and deprive Africa Resources Limited to the right, title, and interest in the equipment through the agents of Peter. 6. Peter did not outlay any funds of its own in relation to the assertion made by Mr. Mokoena in his meeting with Mr. Attendorf. 7. After paying a bribe of 2.7 million US dollar, the purported reconstruction order or consideration for the decree being issued by Chinamasa, the hold on Sweb Zimbabwe Limited equipment by Chinamasa's agent Gwaradzimba was released, and Coca-Cola Africa through Sweb Zimbabwe Limited acquired title to the equipment without following the prescripts of Section 25 of the Constitution, notwithstanding the fact that Coca-Cola Africa is a South Africa juristic entity. Any dispute regarding the relationship between Sweb Zimbabwe Limited and Coca-Cola was resolved when Mr. Mokoena, in his capacity as Sweb Zimbabwe Limited's agent, advised Mr. Attendorf that Sweb Zimbabwe Limited was CCA's subsidiary. Point 8. Any dispute of the existence of a relationship between Peter Mawere Africa Resources Limited in relation to the Sweb Zimbabwe Limited recapitalization was disposed when paragraph 8, 9, 10, 11 and 12 are properly constructed which implicate Peter in the equipment ownership dispute. On paragraph 8, Mr. Mokwena's brief to Ms. Attendorf's brief is clear and instructive that some of the recapitalization equipment has been installed, meaning that the only equipment that was in reference to was the Peter equipment. It is instructive that Gwaradzimba, in his capacity as Chinamasa's agent, advised Coca-Cola Africa, Flame, and SMM, both Zimbabwean registered companies, and as such subject to Zimbabwe's stringent exchange controls, had paid some of the money owing to Peter Trading. This information would have led any independent and impartial liquidator to ask the following pertinent questions. 1. What money was paid by Flame or SMM that was purportedly connected to the Sweb Zimbabwe Limited recapitalization matter? 2. When was this money paid? 3. How was it paid? 4. Who paid the money? 5. Did Coca-Cola Africa verify this information before proceedings to pay 2.7 million US dollar in relation to the purported relationship between Flame, SMM, and Chinamasa's control? 6. What informed Coca-Cola Africa to accept Chinamasa's version through Gwaradzimba that SMM had acquired the right, title, and interest in the Peter equipment? Did Van den Havre take any next steps to verify the veracity of this material allegation that Flame, SMM, paid from Zimbabwe to Peter the alleged funds in relationship to the Sweb Zimbabwe Limited equipment? A fax from one of the suppliers of the Peter equipment clearly shows that Mr. Mawere, on behalf of Africa Resources Limited, visited the company in Munich, in Germany, in relation to the equipment and handled the negotiations to finality, and it was represented that Peter was going to be involved as Africa Resources Limited's agent, implying that Van den Havre was compelled to establish the bona fides of all the value actors in the chain of the European suppliers to the delivery of the equipment that was admitted as early as 2006 by Coca-Cola Africa after paying the bribe of 2.7 million US dollar to Chinamasa for him to use public power to issue a cassette on Cavan's letterhead. The 2.7 million US dollar was apparently paid to another Chinamasa's agent, and such Mawere, Peter and Africa Resource Limited knowledge about this corrupt deal falls outside their personal knowledge, and only Coca-Cola Africa has the right, title and interest to the stolen funds on the back of the theft of equipment that neither belonged to government of Zimbabwe and SMM under reconstruction. The inquiry should also examine the legal status of SMM at the time $2.7 million exchanged hands. Why this creature, an organ of the government of Zimbabwe or a company as universally understood. Point 10. It is not in dispute that CCA, Van den Havre, and the Master of the High Court have known that Mr. Mokoena represented to the lawfully appointed joint liquidators of Peter that it was Gwaradzimba who advised Coca-Cola Africa it should pay Flem and SMM under Chinamasa's control in order to get the Scraps Zimbabwe Limited plant back, which from the facts known so far was Peter's equipment pursuant to the contracts furnished by the late Kaplans on 30 March 2006. Yet the duties imposed on all natural and juristic persons were knowingly and internationally ignored and neglected to date. 11. It was known to all that cash equivalent in lieu of the CCA payment to Chinamasa was $2.7 million. 12. It was represented that Coca-Cola Africa voluntarily chose to misdirect the $2.7 million in relation to the recapitalization of Scraps Zimbabwe Limited project to Chinamasa, and though it was represented to Mokoena that it was the administrator who agreed to release Scraps Zimbabwe Limited Flem from reconstruction, when no authority existed for the administrator who was appointed to perform only administrative functions in relation to the affairs the companies he was appointed to administer. He lacked title and jurisdiction to place Selenov TAP Zambia, Scraps Zimbabwe Limited, Flem under his control. The legality and validity of the representation that Gwaradzimba agreed to release Scraps Zimbabwe Limited and Flem from reconstruction. 13. It was also represented to Peter liquidators that the property belonging to Peter was given to Coca-Cola by Gwaradzimba, who lacked title and jurisdiction to advise Coca-Cola Africa to direct the payment of bribe of $2.7 million to perpet equipment payment in relation to equipment needed by SMM under reconstruction when no facts existed or were provided in relation to the Peter equipment supporting Chinamasa's fraudulent claim using Gwaradzimba that the conduct of Gwaradzimba and Coca-Cola Africa in relation to Peter's property could pass the constitutional muster to permit Coca-Cola Africa to take title and interest from Chinamasa and not from Peter. 14. It is not in dispute that Coca-Cola Africa, without any court order to rely upon, voluntarily adhered to Gwaradzimba's unlawful prescription, and as a consequence, Mawere and Africa Resource Limited right, title and interest in relation to the Scraps Zimbabwe Limited equipment purchased and conveyed through Peter was taught through an organized fraudulent scheme involving CCA and Chinamasa. 15. It is significant that Mr. Mokoena asserted to the Peter liquidators, purportedly represented by Ms. Attendorf, that Scraps Zimbabwe Limited or Flem were removed from reconstruction after paying $2.7 million in exchange for the government gazette by issued using public power by public office bearer Chinamasa to the prejudice of Mawere and Africa Resource Limited and Peter as agent. Point G. The facts regarding the equipment ordered and paid for by Peter. It seems that no dispute exists as to the sequence of events and the fact that Africa Resource Limited caused Peter to act as an agent in the procurement of this equipment. However, the double payment was intentionally and knowingly orchestrated by Coca-Cola Africa as part of an orchestrated scheme to cause the control of Africa Resource Limited in relationship to Flame SAMM Swap Zimbabwe Limited to be divested and deprived from it using public power, and in relation to Peter using Mr. Dan Havry, who has known the facts regarding his travesty of justice that he led Van den Molen Private Limited and she controlled to be unjustly enriched to the tune of 1 million rand, whose equivalent amount today is 3 million rand for just no cause. Age. The unquestionable and egregious conduct by CCA, supported by Mr. Van den Havry, has been brought to the attention of the Master of the High Court in terms of my letter dated 9 March 2003, and link can be found here, whose hard copy is marked EN2.I. The Master has also refused, failed and neglected to respond or take action as prescribed in terms of the Constitution and the prescripts of the Companies and Insolvency Act, suggesting that the justice system is in truth and fact broken. We end here. Thank you for watching. We'll meet again on the next episode. Thank you. Fire Danke.